We're on Section 7, which deals with insurance practice issues, including 176D and 93A. And we've got some cases. We also have to talk a little bit about Rule 56 summary judgment and modern summary judgment proceedings. So I want to start with Rule 56 and talk a little bit about it because it's a very important civil practice rule that goes well beyond what the rule simply says, and you should understand how the process and procedure works these days. It's a lot more involved. But Rule 56 is what I call one of our testing motions. It tests the pleadings and the case taken as a whole, which means not just the complaint, but the answer, any other information you choose to submit by way of affidavit that you've obtained through discovery, and assesses the case in its entirety to determine whether the standard is, are there material facts in dispute that rise to a triable level? And if not, the moving party is entitled to judgment as a matter of law. So in essence, what it becomes is a test of who should win under the law, because if there are no material facts in dispute, we don't need a jury to resolve those facts. It simply becomes an application of what the law says, and under those circumstances, the judge is able to determine who wins under the law. So it starts with the ability of the moving party to show the absence of material facts in dispute. And what that means is not that there aren't potentially factual disputes, but they're not material. Material, we borrow that reference from evidence, means that they aren't of consequence. There may be disputes factually, but they aren't of consequence to resolving the matter, because under the law, the facts that we do have allow us to determine who wins and who loses. So when there are no material facts in dispute, and we add to it that rise to a triable level, because that part of the definition, what it means is that it's not enough to simply say we dispute the other side's version of the facts. What do you have to provide to the court to show that that dispute rises to the level where you have some evidence to support it, evidence that at the end of the day the jury could look at and potentially, not mean you win, but at least potentially have some offsetting evidence to show that there are in fact factual disputes that would warrant a jury trial as opposed to simply the judge applying the law. When you move under Rule 56, you have to do so by way of a motion, supporting affidavits, and a memo in support of the Rule 56 summary judgment motion. But that really, these days, is just the start of the process for moving under Rule 56. Whether you're in federal court or state court, most have specific rules as well. If we're in Superior Court or if we're in federal court in the First Circuit here, they have specific rules that also require an additional significant amount of material. Generally, what they require you to do is file a statement of facts, uncontested facts in essence, with the summary judgment motion, and also to what extent you feel that there are disputes of the facts, and those oftentimes have to be supported by record references. So what you're required to do really is to meet, to try and see to what extent there's an agreement on the combined statement of facts. What do we agree the facts are, if there is any agreement? And if one side simply provides the statement of facts and you dispute it, then you're going to have to find references in the record somewhere, references in the evidence, whatever you have that you will be able to produce at trial to show that the facts are other than what the moving party says. And that is a significant amount of work if the case has any type of breadth to it whatsoever. I've got one upstairs from just a couple years ago. The summary judgment papers were probably about 1.5 feet thick. It was weeks of work to oppose it. I'm sure it was weeks of work to present it in the first place. And it always strikes me as a little odd that it takes 1.5 feet of materials to say there's no dispute of material fact, because clearly, if that were true, you should be able to say it pretty succinctly. But in and of itself, that's not enough. And if the proper procedure isn't followed, the motion's going to be denied at any rate. I call it a testing motion because while the standard is somewhat strict, depending on who you're before, the judge may or may not interpret as strictly as they should. Some judges favor the right of a jury trial and the right of a jury to resolve disputed issues of fact. Other judges are much more liberal with respect to resolving summary judgment without a jury. To some extent, I think that's to some extent that is an invasion of the jury trial right. But as a practical problem that you've got to address with this is that if the judge gives every civil litigant who's requesting that jury trial a jury trial, they're going to have a significant backlog of cases, and then someone upstairs is going to be telling them that people are waiting too long for hearings and trials, and you're not disposing of enough cases because someone tracks all of that administratively. So there's some tension from that standpoint. It doesn't seem like your constitutionally guaranteed right to a jury trial should simply bend because of administrative orders and the like. But as a practical matter, I think you've got to think about that. When you tell a judge that I've got a 3-day trial or a 6-day trial, and we need to put it on the schedule, the fact is that the judge is sitting there in part thinking about, well, what's this do to all the other cases I've got? And so summary judgment is a means for the court to dispose of cases that the court doesn't see are sufficiently worthy of going to jury trial. The problem is, for many litigants, summary judgment will be the end of the road. We say, well, if the court made an error, we'll take our appeal, we'll move it to the appeals court and see what happens. The fact is that's more expense, more delay, and so you got to try and win at the trial court if you're going to be able to hold the judgment on appeal. But the fact is, at some point, litigants run out of money, and so summary judgment can be a means, especially for defendants, to try and prolong and make the process more costly and potentially win and knock the plaintiff out from having their jury trial. So you've got to understand the process of summary judgment. I think you got to push the limits of it to some extent if you're the defendant. And plaintiffs can move for summary judgment as well, but since the plaintiffs have the burden of proof, sometimes it's harder to show the absence of a material fact and dispute. But it's not impossible, and in many cases that you may move for summary judgment, for instance, as to liability and not as to damages, or both. Because the court can also issue what's called partial summary judgment on some of the issues, but not all, reserving the matter for the others. Well, what I really want you to take away from this as well is that it's not just any longer a simple, 1 or 2 page motion. It's you really got to assemble a lot of other material with it if the case has any breadth to it, meaning that, if you've been in discovery for a while, if there are a lot of relatively contested issues, that's going to be an involved project to be able to show to provide the court what you need to provide them with in order to move for summary judgment or oppose it. And at $300 an hour, if you spend 30 hours doing it, that's a no-brainer. That's a $10,000 project. Obviously it's still less than what it would take to bring the matter to trial, but 30 could be light, depending on the size of the case. Questions on summary judgment? It's an important weapon. It's not just a weapon, obviously. It's an important procedural device that's used by both plaintiffs and defendants, but it does bump up against the right to a jury trial. And the fact is that the court is somewhat stringent on providing everyone their right to a jury trial simply as a practical matter. It would congest the court docket too much. Doesn't seem right, but it is what it is.
Can you move for summary judgment once early in the case before there's not much discovery, and then like again later on?
You can. There's nothing that precludes that. I think a lot of people worry that if I move early and lose, the fact is then, and you would do it, right? If we were opposing it, the first thing you'd say is, Your Honor, they already moved for summary judgment a year ago and you denied it. So I mean, I would too, right? That's the first thing I would say. But the fact is, the situations, especially in civil litigation, can change significantly from the beginning of the case till later in the case. And so what didn't appear to be an issue early on can be a bigger issue later on, or what appeared to be a hotly contested issue, now we've got evidence that clearly shows that, okay, he says it didn't happen, but there's ample evidence that it did. So there's nothing that prevents it other than, I think, the worry that the first argument coming out of the opponent's mouth is they moved and lost for this already. But by the way, the same argument can be made when we talk about equitable remedies and the like, is I might move for a temporary restraining order, preliminary injunction early, and I could lose that, but the facts change during the course of it. There's additional damages or injuries that are suffered, and if the situation warranted it, I would go back, recognizing that the first argument out of my opponent's mouth is, Judge, you denied this 6 months ago. But so then, and you should recognize it as well, so what has changed? Because if you're just back to make a pain in the ass of yourself, the court's not going to listen to you. What additional facts have you uncovered that now warrant it? What law do you have additionally now that supports your position? As long as you have that, there is nothing that prevents either, other than the practical argument that you know is coming. Yep?
Professor, that's also limited by the 30 days after the submission
the summary judgment materials?
Yes.
Yeah. Well, what do you mean limited by that?
I mean, if I understand it correctly,
yeah.
I may have misread it.
No.
You could file within 30 days of
the complaint?
discovery, of all the discovery. Once all discovery is submitted, you have 30 days. And then
not necessarily. Not necessarily. Sometimes there'll be tracking orders which will stage exactly when the motions can be filed, but more often that tracking order is going to say they must be filed by a certain date, not that you have to wait till that date. If you actually look at Rule 56, it allows for, and some parties will do this, they will, once the complaint is filed, they will move to dismiss, or in the alternative for summary judgment. You could face a summary judgment motion right out of the box. And part of the reason it's done is that it's a motion to dismiss. In essence, on the face of the complaint, it fails to state a cause of action for the following reasons, whatever, substantively or procedurally. However, the rule talks about if you look at anything other than the face of the complaint, affidavits and the like, then in essence you're going to convert it to one of summary judgment anyway. So there will be times where parties will, right out of the box, move for summary judgment on the basis of your complaint. Sometimes on the basis of the complaint and the answer. You know, suppose the defendant agrees to everything the plaintiff says virtually. You have got two motions you can do. Motion for summary judgment, a motion for a judgment on the pleadings. Either way, we look at the complaint, we look at the answer. They're not disputing the facts that are important to the outcome of the case. So the fact is you can move really any stage of the proceeding. Usually the court is not going to entertain a motion for summary judgment until the defendant has had some opportunity for discovery. However, if the motion for summary judgment is moved prior to discovery beginning, then it's the defendant's obligation to file what we call a Rule 56F affidavit. The Rule 56F affidavit says, if we're allowed discovery, we will be able to show facts in dispute. We haven't had the opportunity yet. Here's what we think we'll find through the course of discovery. And so you can sort of postpone it with an attempt to get discovery, but sometimes summary judgment will happen before you even have an opportunity for discovery. The way Rule 9 works in the Superior Court and the way the federal court local rule works, when the moving party files it, there is an opportunity to respond, and then those documents at some point, and I don't know what the actual days are in each, have to be submitted to the court. And that may be with a 30-day sort of the timing and response issue comes in. But it's much more likely when we're looking at summary judgment, we're talking a couple weeks to try and work that response. And a couple weeks, this case I had, it had over 30 depositions. It was a relatively complicated case. But it was just an injury that took place at work, not a workers' comp, but the harassment, discrimination, and things like that. So we had we had medical testimony, we had lay witnesses, we had over 30 different depositions. But it wasn't like a big commercial case where you'd have lots of problems, and it's still, I bet summary judgment ran 25 grand both sides in that case. No doubt about it. No doubt about it. No doubt about it. 25 grand would be what, 60 hours? Yeah, easy. If you saw the papers, you'd understand. It's just easy 60 hours. And so, but it's a big case from a dollar value standpoint, so it's worth trying to do that. And I think, especially from the defendant's standpoint, it's worth it to try and keep that case out of the hands of a jury. And that's what the goal was. There's obviously a lot of other cases where summary judgment is, a few pages. Sometimes in the past, we've moved for summary judgment. It's based on really the complaint and the answer. If you look at the two things, there's some dispute, but those dispute aren't material. What's disputed here isn't really material to the outcome of the case. Judge, we should win. So sometimes summary judgment is relatively thin. The modern practice, though, and I think in part the court wants you to really go through this process and think about what you need for trial and how much trial time you need, is to really think about where you are, where you stand, and it forces. And it, by the way, the whole process now absolutely sharpens your understanding of your case and the factual issues and what you need for trial and what you don't need for trial any longer. I mean, it's a process that is well worth it for the advocate. Problem is, it's not an inexpensive process. And the last point I was trying to make, and I didn't make it as artfully as I meant to, and it ties to this about the trial time and the court scheduling it. If you want a trial date sooner rather than later, as a practical matter, you tend to underestimate how long it's going to be. Okay? It's much easier to schedule a 3-day trial, or to at least get on the agenda faster for a 3-day trial than if I tell you it's going to take a week. Because a week, you say I lose the whole week then, right? Psychologically, the court's saying I'm going to lose a week. And if you tell me it's 2 weeks, then I'm thinking, okay, so we ought to put it further down the list. Obviously, you have an obligation to the court to be honest with them. And if you're looking at a 14-day trial, let's say 10 days. When we talk 2 weeks, we really mean 10 days. If you've got a 10-day and you're telling them it's 3, you're going to pay for that. Okay? If you got a 3 and it spreads to 5, that's probably okay. If you got a 5 and it goes to 8, that's probably okay, because you can't control everything. But if you call it a 3 and it's a 10, you got a problem when that case gets tried. And the other part of that is, if I want to delay it, oh, Judge, this is going to take at least 2 weeks. 2 weeks, and I'm losing half a month, right? Well, you're going to get a trial date, but you're not getting it soon. Whereas a shorter date and a shorter case can fit into a schedule much easier. So that's the other part of this, is that the more there are practical ramifications to how summary judgment and how some judges will operate with respect to summary judgment, and how your guarantee under your Seventh Amendment is sometimes not as guarantees as it should be. Because the rule's pretty clear. If there are material facts in dispute, that case should go to trial. But that's not, that some judges, and you need to know this, by the way, you need to know what the standard your judge uses, and not just the standard. They're going to quote the right language. What do they see as jury-worthy, and what do they tend to turn away from, even though there may be some disputes?
What if in your not your opposition, what if when you're moving to do summary judgment, you kind of like, you want the facts, that there are no facts in dispute.
Right.
So you kind of like work it so that it's a good motion for summary judgment, but then it does go to trial, you lose the motion, and then you're kind of like backtracking to kind of, you don't want the facts to be the same for your trial tactic. You want to kind of like change that a bit.
Well,
I mean, it's a fact, but you know what I mean.
I know what you mean. But you said it was, listen, it's a judicial admission. You're bound by what you said was a non-disputed fact. And I'm going to hold you to it, and I can try and hold you to it. Mark actually raises a different issue that you need to think about. To some extent, the moving party is somewhat at risk by saying there are no material facts in dispute. Because when you do that, you're saying no material facts in dispute, judge, you decide who wins and loses. Well, if it's simply a question of law, the judge could agree with the first part of your proposition, that there aren't material facts in dispute. However, you lose under the law, right? If it's a question of law, then the judge can, in fact, determine that while you're right, there's no factual dispute, you're wrong on the law, and you lose. So there should be more trepidation for some in arguing there's no material facts in dispute. What they tend to do, though, is focus on only the ones that favor them and say there's no material facts in dispute as to all of this, and therefore the defendant should lose, or the plaintiff should lose, either whoever they're opposing. They don't tend to, you're not going to go out of your way to find that little piece of fact that says, oh no, that doctor's wrong. We've got contrary medical evidence, or that didn't happen the way the boss said. We had witness X testify to Y. But this is why it becomes a real chore. If you haven't, well, A, you should have digested your depositions already when they were done. Digest means simply being able to track what took place where, like you guys do an outline for your cases, right? When you're supposed to do an outline for the semester, all of that material you digest down. Well, that's a deposition digest. So if we've done a deposition for a day, I've got a digest of the important facts there that's been done, so I can quickly find the right reference I'm looking for. So that had to be done. Even with that done, you get over 30 depositions and you've got, say, 15, 20 fact witnesses. I think it was Marsha who said, the sky was blue that day. So now I go to Marsha, it's not Marsha. So now I got to find out who it is. Now I got to start looking at the others. That's why the process becomes expensive, is there will be times where you're looking for that little kernel that came out of one piece in the file, and you're struggling to find it, and then sometimes you find it and say, oh, it's not exactly what I thought. She said baby blue, not navy blue, or whatever it is, type of thing. And so now you've got to go back and be able to figure out how that works for your case. So it's not that they would tend to admit, for instance, this case I described to you, the employment issue, they never would admit they fired him. They just would not. What they were saying is he walked away. And he didn't walk away. He walked away because they made his life miserable and constructively discharged him. But they would never say, and so in essence they fired him. Okay, they did. They couldn't live there anymore. He was constructively terminated. But they would never agree, even in the statement of facts, and I wouldn't either, because technically we didn't fire him. We just made the whole work experience so damn difficult it would have broken anyone. And so they're not necessarily going to admit we did wrong so that it could be binding. They're going to try and still paint it in the best possible light.
So they stipulate to the facts they want to, sort of.
Well, it's not stipulation. It's that they're saying, this is what the evidence shows. This is what we've got. And then it's incumbent on me or whoever's opposing it to say, no, that fact's not true. And here's where in the record there's evidence that says that is contested. And you've got to do that for every one. And that's why it becomes an expensive process. It's a good process, and it's important to do because it shapes the case you're going to try anyway. And it helps sharpen. You got a much better inclination as to how they're going to focus, but you probably knew that anyway. It just requires you now to be able to be ready and to have those references so that you can make a quick recall on them. The whole point is to try and avoid what is even more expensive, obviously, is a prolonged trial where someone's going to lose. And so if you think you can win here, and especially from a defendant's standpoint, if I think I can make it more expensive for the plaintiff to continue to pursue, then maybe they'll walk away sooner rather than later. And so it becomes a significant weapon for defendants, because there'll be some judges that will, to a much greater extent, be liberal in granting it, even though it invades the right to a jury trial. Anything else? But admissions you make in the pleadings, I'm going to use, and so is any other advocate, right? You say we terminated him. You say, yeah, we accused him of stealing radio. I'm going to use that because at one point it's contested. Now you say no, we agree. We brought him in for a reprimand because we accused him of stealing a radio. Great. I've got one less thing to worry about. I can prove it through the pleading, through the admission, right? It's a party's own statement, admitted through an authorized agent, their lawyer. I got no problem with that, so I'm going to use what's there. And of course, you're going to take the best parts of it and bolster your argument. The problem is a smart advocate's going to write it in such a way that it won't be as usable as you might like. A good advocate's going to do that, but not everyone is a good advocate. Questions? Let's talk about the Timpson case, which is one of my favorite cases. But Timpson is really here for respondeat superior, not for the rest of the interesting aspects of it, but it is an interesting case. Michael Timpson was a New England Patriots player. He was in his locker room. Lisa Olson was one of the first female reporters. Back then, she was covering the Patriots for the Boston Herald. And Timpson, along with others, were in the locker room. And Olson says, and I don't think it's really much dispute about it, that various Patriots players made rude, crude, sexual remarks to her in an attempt to humiliate or embarrass or whatever. And then at some point, she sues the New England Patriots and the players involved. And Timpson, who was in fact an insured under the policy as what we call an additional insured, had to defend the suit, and they defended it under what we call a reservation of rights, meaning that we'll defend for now, but if you're outside the scope of your duties, there's money to be paid to us because we're not agreeing to defend you. 176D is what he's charging them with violating, 93A and 176D. 176D is the Insurance Practices Act, equivalent to 93A for other businesses. 176D regulates various activities that insurance companies are required to undertake. And not only, as for the most part, under the policy of insurance do they have an obligation to defend the claims brought against you, but also once liability has become reasonably clear to try and settle the claim under the terms of the policy so that the insured isn't exposed to an excess judgment as well. So Timpson says that this all should have been covered by his insurance, the insurance policy covered by the Patriots, and the fact is that I shouldn't be out nearly $90,000 in legal costs and attorney's fees. So he sues Transamerica for violating 93A and 176D. And Timpson is adamant that his conduct was within the scope of his duties as a Patriots employee. Transamerica is equally adamant that this can't possibly be within the scope of your duties as an employee of the Patriots. But it could be, couldn't it? What's that look for? I don't know what that looks for. I don't. He was required as part of his duties to talk to the press, to engage with the press, right?
She wasn't even talking to him.
Huh?
She wasn't even talking to him. She was talking to his teammate, and then he just comes over naked and starts.
No, he didn't. He was just encouraging.
He was
He encouraged.
She was encouraging him. All right.
Zeke Mollard was.
Zeke was naked, and he was encouraging. Huh?
Several were naked.
Well, let me ask. Okay, you say several were naked. You're in a locker room of professional athletes.
She should.
And she should what?
She should expect to see naked men in the locker room after the game, but they shouldn't. They shouldn't be all coming up close to her.
Well, but the locker room is a relatively small space. I mean, you said she should expect to see naked men in the locker room, but she shouldn't expect naked football players to act what, irresponsibly? Seriously, is that because?
Yeah,
that's it. Because see, I've always had a problem with that. I had a discussion with my neighbor across the street that football players have a screw loose. Her kids used to play football, so she took exception to that. No, don't you have to?
Look,
right? I used to play football. You had to have a screw loose, didn't you? You run at great distances from each other. You put your head down, and you're supposed to hurt the other.
You enjoy
right?
contact.
Huh?
So you enjoy contact.
Right. Right. So, is it really unfair to expect that these guys who do it at that level, obviously, are suffering significant, and now we know even more than we ever knew about significant punishment on a regular basis?
Diminished capacity. I like the idea.
No, it's not diminished capacity. It's his point is, I was building team unity. I was doing what I was paid to do. And because if I had my druthers, I might not want female reporters in the locker room at all.
Okay. Which was the reason they did not want a female in that locker room. That was a 26-year-old woman who went in there doing her job at the cusp of being that first generation that women can be and do anything. And these knuckleheads decided to be rude and tried to scare her out of there.
But I think that her choice of doing the job was a poor choice, wherein she did her job. She could have chosen a conference center, or she could have made arrangements otherwise. No male reporter goes into the women's locker rooms while they're showering to conduct it. So it's a double standard in that regard.
I agree. I think that, look, I understand both points. Like, look, you have women, especially at that time, like, she wants to be treated seriously, and she's in there and they're making a mockery of her, which is horrible. However, they're in a men's locker room. You know what I mean? Like, if this was in a different setting, I think it would be so egregious. But where they're in a men's locker room, they just finished a game, they're riding high on life. I just think that I think they should. I don't think there should be anybody in the locker room. Never mind a woman. You know what I mean? Doing an interview with naked people. I think it's ridiculous. So, I mean, yeah, I don't know. I just don't think it's right that they should be in there in the first place. Never mind. I think that the insurance company should definitely, and the team should have united the owners and backed them up. You know what I mean?
So she should expect to be sexually assaulted because she's trying to do her job. Huh?
I mean, can I go in the girls' bathroom at MSL when I leave here? And, you know what I mean? Hey, I'm just doing.
Again, I told you no.
Go ahead, right now. You know what I mean? What side do you put the toilet paper on? You know what I mean? Like, you can't. It's.
Regardless of sex, you're asking for problems when people go into locker rooms. I know, obviously, that it's not right. They probably didn't want a woman in there, and they definitely crossed the line. But it's not up to them to make sure reporters aren't in there. But back to the case, I honestly thought he was going to get off of it up until he lost me when he made the argument of promoting team unity.
We're going to let that one go.
That was laughable.
I thought he was going to get off of it until then that they explained the three-part test and they said, oh, well, I'm promoting team unity. I think a different argument could have been made.
Yes.
A stronger one. Team unity, I don't think would have been the strongest argument to go with there.
Well, what is the three-part? You said the three-part test. What's the test called?
The weighing test. No pun intended.
So what is the three-part test?
It is the conduct is of the kind he is employed to perform. Number 2, it occurs substantially within authorized time and space limits, which I think they agree that number 2 is satisfied here.
Well, do we all agree? I mean, this is authorized time and space. It's a locker room. He's required to engage with the press, so he is in the right place, right?
And then number 3, it is motivated at least in part by a purpose to serve the employer.
And he needs to meet all 3.
Yes.
Right. So Number 3, it's motivated, at least in part, and that's all it's got to be is in part, to serve the employer's interest. And what was 1 again? Oh, it's the type of work he is employed to perform, right?
Yeah, the conduct.
The conduct, right. I'm sorry. It's a type of conduct he is employed to perform.
He relied on a baseball case where a pitcher threw.
Well, I want to ask you about that. Before we get to Grimsley, let me ask you about the first part. Isn't in part this is the type of work he's employed to perform, to engage with his teammates and to camaraderie?
Somebody?
Huh?
To sexually harass somebody?
Let's showboat when they score a touchdown. They jump around and chest bump and all that.
Yeah, could you argue a hostile environment just being in there and the kind of jokes? Like, what if they just weren't? What if they're in the next thing, like, and they're joking around inappropriately in a men's locker room, like men may do? I mean, could she still file a claim for sexual harassment in that aspect? You know what I mean?
Go ahead.
As a woman playing with men all my life, when you go into those fields, you have to be aware that that's going to happen. You're going to be harassed. There might be some jokes. You have to have a tough skin. Either you take it and leave it, or you take it and respond. Now, to the fact where they go around her and are naked and start around her in a circle, like, that's pushing it the limit. Like, there's personal space between us, and that's not the normal, typical guy hangout type of space. She's there doing her job, performing. Plus, he's there representing the Patriots, which are a common known worldwide football
Not back
league.
then.
And also go against their image for their company.
But is it customary for them to engage? I play football, and I'll tell you, the stuff that goes on there, whether you're a woman or not, there is harassment with each other.
Well, now we know it's even
pushing.
for Florida, right?
Yeah,
We know the Dolphins case. No, really, right? We know it's
So there's a lot of that going on. Certainly, there should be a heightened sense.
was one of these guys.
You know, I don't know, they should be a little bit more careful with how they act because there's a woman. But the fact is that she assumed the risk of going in that locker room knowing that that is the culture of the sport and that's the way that they act. You know, conversely, a man does not go into, let's say, the woman's locker room when they win a soccer game or something to that effect, because they are not allowed. So I think it's a double standard. If she wants to do the job, I think that she could have chosen another forum to do the job. And going into the lion's den, let's say, those things were bound to happen. I think she made a quick buck on this.
I don't think that would happen in our days.
Well, even
Go ahead. You have to.
Well, you're like harassment happens, or I'm sorry, hazing happens all the time. So you're saying like you can't join a sport like because you're going to put yourself in a hazing position. So she can't go in a locker room because you're going to put yourself in a sexual harassment situation.
No, that's
Like-
outside of the context.
Well, it's kind of like
Hazing, no. Hazing,
because it's known
probably,
to happen in there. Sexual harassment and like that whole like whatever happens in the locker room stays with whatever guys do in the locker room. And like girls involved or whatever, like that happens. So like you're saying like hazing, whatever, that happens, it's illegal too, just like sexual harassment.
Well, no, hazing is one thing. The culture of the sport and how the guys act among each other when they're in the locker room is another thing. It's not considered, there's a fine line between hazing, let's say, which was deemed illegal, which could be harmful to someone, and the joking and everything else, which is consensual. To the degree that it is expected, and in fact, as crazy as it sounds, it's a male bonding thing. It really is.
But you don't think this would be harmful to a potential female to have this type of activity happen?
It doesn't happen.
Oh, so I mean, if they're going to surround her.
Because if it happened somewhere else in the locker room, other than the locker room, you'd be arresting these people.
Oh, absolutely.
Right?
Absolutely. It's just, I think that to a degree, she kind of knew what she was walking into. I mean, obviously, she didn't, say, hey, surround me.
No, that's
What are you saying back there?
She wasn't intended to walk in there and be treated that way. She wanted to be treated like her fellow reporters would be treated.
But you knew it. You even said she was one of the first. In fairness to the point, you know this is not a friendly. You're not facing a friendly audience here. They don't want you there. You shouldn't. As they see it, you shouldn't be there. This is a men's place.
Right.
And
they were
don't want
feeding
male
on that.
reporters.
right, as Jim has pointed out. Will McDonough and Maurice Hurst, another one of the players involved in this, Will McDonough knocked a male reporter for the Globe knocked Maurice Hurst out over a dispute they had in the locker room as well. So and by the way, I imagine there must be tons of athletes in Boston who would knock Dan Shaughnessy out if they could. So I mean, it's not necessarily limited, huh?
David Ortiz.
Yeah, exactly. So they don't even want guys there to some extent. So now you've upped the ante a little bit, and I understand. No matter what she should have expected, we still got to get back to Charlie's test to determine whether the Wang test is satisfied or not. Because if he can make the argument that this is covered, that he falls within the 3 parts of the test, as repugnant as his behavior we think is, the fact is he may be able to find coverage under the insurance policy. Go ahead.
And just to touch point, even though it really seems like it's a very sexist case, even today, a lot of locker rooms, they blast very vulgar music so that way you can't actually hear what people say because it's going to be censored on TV. So regardless of whether it's a woman or a guy, if you have a guy in there who's known to ask questions that you don't want to answer because they're the tough questions, they don't let him get away with it either. So.
Let me just make the point that, and I think it was made here, and it's made in related materials with this case. There is the counter argument to say, well, the female reporters or the male reporters then have to stay out of the female locker rooms. They'll just wait for the press conference. Some of these folks will never come out, right? I mean, that's the point about why they want access. That's why she wanted in, is that if I'm going to be a sports reporter, I've got to have the ability to get the same stories that the other male reporters get, or I just won't flourish here. And so that was part of the problem with respect to this case as well. And what's funny is we did a show a few years back. Jackie McMullen was here, and she talked about this case, and she talked about her own experiences as she was one of the first female reporters in Boston who covered the Celtics back then when this case was on. And she said she talked about it at lunch with us. She said this was. This didn't just happen in football locker rooms. But you do have to figure out the balance here, because otherwise, I mean, Lisa Olson left the Boston area. I don't know where. I think she might have went to Chicago after this.
No.
What?
She left the country. She went to Australia. That's where.
Is that true?
That's absolutely true. The Herald had connections with paper there.
Oh, probably Rupert Murdoch.
Death threats, harassed constantly. Her home was burglarized. She gave up. She said, "I can't do this anymore."
That's not right.
No, it's not right.
Happened to Bill Russell in Reading.
So is that normal?
That?
Yeah.
Let's talk about the first part of the test. It's the type of work he's employed to perform. The conduct he's employed to perform. Right. He is supposed to interact with the press.
Cooperatively.
He did just laugh too. It's not like he was the one either.
I think they leave specifics out for a reason, because it doesn't really paint a picture of exactly. I can think of a ton of different scenarios that could have happened here, and they're pretty vague on what actually happened. With him, they say he encouraged, but there's many different levels of encouragement. Yeah, it could just be as simple as laughing, clapping, and pointing, going ah ha ha, and then there could be some more specific things stated. There's all different forms of encouragement.
Well, again, let me just. So, what type of encouragement would you give to someone who's sexually assaulting someone else?
Well, I mean, as bad as this might sound, depending on what it is, I could see myself laughing. I don't know how. No, I'll be honest. I don't know how bad it could have been. If it was terrible, maybe not. But there are some things that I would just look and it caused me to laugh.
It's easy to look back and scrutinize. You know what I mean?
Yeah, that's what I mean. It goes back to the whole locker room.
When I read this, would you want your mother to know you were involved in this? No, would you knew that was coming?
The people who actually expose themselves, they should be punished, and that's terrible. There's no excuse for that at all. But if you're happen to be in that environment at that given point, and maybe the encouragement.
And I don't say, Charlie, stop. I say, go, Charlie, go.
I don't think that's right. But if you see.
But that's him, isn't it? Isn't that him?
They just say he laughed and encouraged. I don't know what that is.
Not everyone's as inappropriate as you, though, you know.
I guess not. But I mean, if you're sitting there and you're laughing, I don't think you should be able to go to court for that and get sued for it.
I don't think it was just laughing. You said he offered encouragement of some sort.
It was vague, though. I feel like that is important, and they didn't really get into that.
Yeah,
It's like you
why
said,
was
just
it?
laughing,
They
I
just
don't think.
laughed and shouted encouragement, that's all they put, so they left them completely
Yeah.
wide open.
Laughed and
exercised his freedom of speech.
That should have been an issue that I don't know, like encouragement.
You're encouraging a sexual assault, right?
Well, encouraging what? I mean, like if someone's dying in a river, I go laugh at them and walk by, and there's nothing wrong with that. I mean, you know, I mean.
Well, that's another thing.
Well, it's not illegal.
We don't. They're also big on what they do.
There's no liability, perhaps.
Right, that's not. Well, that's what I'm just being legal. I mean, you got to draw a line somewhere. I mean, you know, I'm just saying, like, there's no liability. You could literally, you could laugh at somebody drowning in a river, and no liability. So, I mean, you know.
Well, see, they're also vague about what the actual sexual harassment was.
I think he was pushing his stuff in her face.
And see, I draw that inference, but they don't come out and say it. They just say one of them exposed themselves. I don't know if that's as simple as people taking turns walking by or giving a look like, get out of here, or...
That doesn't, like...
He was standing behind her and said, I think, and doing something.
But that's the thing, it's so easy to look back at it now, as
No,
opposed to...
I think you're minimizing what it was. No?
No, I'm just saying it from one extreme, because this looks terrible for him. I'm not going to sit here and deny that. It looks like what they did was wrong, but you want to give different lights on things. You don't want to...
It was probably worse than what they put.
Oh, it absolutely probably was. I'm just...
How do you think
for
she
sake of
felt in
argument.
that locker room?
What's that?
How do you think she felt in that locker room?
Oh, terrible. Of course. But I'm just trying to shed a new light.
But even if it's just encouragement, it's not just then the person that's there, it's the others that don't help. It's the others that seem to make light and all the rest of it, no? I mean, I understand what you're saying is he certainly isn't as potentially culpable as Moat, but he didn't do, and by the way, it's not just him who didn't do anything. The Patriots personnel person who was there, forget what his name was here, he did nothing too, right? No one did anything when you would think. James Oldman, a member of the management personnel for the Patriots, was present during the incident and made no effort to stop the player's conduct. Let me spin that though a different way. So now I'm Timpson. If what I'm doing is wrong, shouldn't management tell me that this is not what's in the scope of my duty? Shouldn't they put a stop to it? Because if he, as misdirected as he thinks, that this is in part the type of conduct he is required under his contract to do, to engage with the press, okay, he's really executing that part of it very badly, but in some twisted capacity he thinks he is. Because if that's his attitude, then he falls within one and maybe three as well, no? And help me with the bigger distinction, I think. Ross Grimsley, you read the note, Charlie made reference to it. You saw that within the case?
Yes.
It's on the bottom of 348. Manning versus Grimsley. Professional baseball player who intentionally threw a baseball toward hecklers and injured a spectator was found to have acted within the scope of his employment because heckler was interfering with the ability to perform, and thus quieting the heckler would result in better performance by himself and team. A professional baseball player throws a baseball at a heckler, hits him, and that's within the scope of his duties.
He was on the field at the time. He was on the field.
And I'm in the locker room.
The game was over. They were in there getting changed to go wherever.
And I am where I'm supposed to be. Now I'm going to shower and be done for the day, but you've put the press person in here who I'm required to engage. So, I mean, is that it? That the locker room is different than the field? Or we just don't like what Timpson and these guys did? Huh?
Aren't they supposed to be like role models? Like, aren't they hired to be a role model as well? And like,
no, they're
help to a higher standard?
You would think so, but that's the problem. Is if you expect these guys to be role models, we got that they're going to fall short of that.
Well, these players have to go to the locker room afterwards. They don't have an alternative.
Right.
They can't just go in the car and go back home or whatever.
So they're still...
I would assume it's part of where they're supposed to be employed.
Oh, I think so. If one of them got, legitimately got hurt in the locker room or hurt another in the locker room, I would think that you wouldn't have the same issue. Suppose the two of them got in a fight because you should have done this or that on the field, I didn't. I'm not so sure the locker room is different than the field. So what's the difference?
I remember this case, and they said this clearly wasn't just female. Any new male reporter they harassed too to see if they had it to stand up to them.
So where are you going with this?
They're saying that
this is part of this.
Female, they didn't want anyone in the locker room, and if you couldn't hang with them, they were going to push it to the very limits that they could.
To make it uncomfortable, you leave. I don't care whether you're a guy or girl. Get out.
They did it as a team.
Huh? And they did it as a team.
If they didn't want you in the locker room, why would they allow it in the first place?
They don't allow it.
It's good for the NFL and the Patriots.
That's
because
mandatory by the league. The NFL forces that.
It's cheaper than buying an ad in the paper. You're going to put it on your sports, you might leave with your newscast, and now you're going to buy a ticket. Huh?
They don't have to allow them into the locker room.
Yes, they do. The NFL absolutely mandates.
The locker room gives them that access that the news stations and the TV and the reporters want. It's free publicity. It's free publicity, right? After how many of these games? Listen, I watch after the football game's over. I watch the fifth quarter. I watch the rest of it because I can't get enough. So we do now, and now they just commercialize it to a greater extent. But it's helped what make the NFL this multi-billion-dollar business.
I mean, but publicly, Bill Parcells would publicly humiliate.
Right. Well, listen, Belichick, even still, on occasion, you see the disdain when someone asks him what he, in his opinion, thinks is a stupid question, and you think he'll even say that. So, I mean, they understand that this is part of their job. They don't like this part of their job. But so wait a minute though. So I'm still trying to distinguish the Grimsley case because
it was in 1920 or 10. That's probably
no, it wasn't. No, it wasn't. Grimsley. I remember Jim told me about Grimsley pitching.
I thought
no, Grimsley's not that old. I remember Ross Grimsley pitching. That can't be from that. This is 1981.
I don't want to.
No, he's not that old, for God's sake.
For the umpires to this day, they'll call a fastball and just let it catch them all move, and they'll let them drill them.
Right.
And nothing happens.
So wait a minute though. So what's the difference? Because this clearly, this is a criminal act. It's outside. Where the ball ends up is outside the field of play. So he satisfies. The conduct is the type of work he is hired to do. Throw a baseball. Speak to the press. Authorize time and space limits. And 3, the conduct, at least in part, is motivated by a desire to serve the principle. Go ahead.
Yeah, I think that's where the deficiency is, because the baseball player, in the case they said that he was, in hitting the heckler, he was attempting to quiet the heckler, which would then have improved his
team's performance
on the field. Here, sexually harassing a reporter wouldn't. I know that he said that it would build team camaraderie, build morale, and then they would be more cohesive on the field. But the court didn't buy that, and I think that's kind of a stretch.
But do you
physical assault?
No, but do you? Is it really a stretch to say that they're all joking around, having a good time, and now I'm gonna be the guy who calls the party over and then say you're a bunch of jerks because now I'm odd man out. We're not laughing and joking anymore, and to some extent, I've called them on reprehensible behavior. Again, as he's filtering this through, can't he fashion an argument that, well, I think what I'm doing is right? Hindsight says I'm not. Because really, Grimsley, he throws a baseball likely at a significantly younger person, hits them in the face with the baseball, and that was saying, oh yeah, that's motivated in part to serve, I think it was the Baltimore Orioles at the time. Really? Really? That wasn't just you were done with listening to that, whoever it was?
I don't have a problem with that one.
You don't have a problem with that?
A baseball?
Someone wants a baseball.
That's battery. That's worse than sexual harassment. If you beat the crap out of her, it would be okay.
Well, then, yeah, right, you can't, yeah, they should have punched her in the face, they'd be okay. No, right, you can't say, that's the problem, you can't say that.
Should have taken a football.
Well, for me, the distinction is that he was in the field of play. These guys were done, they were in the locker room, and I actually agree with him. She had no business being in there. She didn't expect that some of that was going to go on, that she was going to see the naked players, whatever. I mean, they went over the edge. They shouldn't have got, all too close to her. But, they come off the field, they're playing a game, they're all ramped up, the adrenaline's going, the testosterone is flowing. I mean, you have to expect that. I mean, they're, guys.
But even with the expectation, she should still recover. Because what they've done is a sexual assault.
They crossed the line.
I think it was a good call on, Grimsley was a bad call, but I think that the court may be distinguishing between the intent, the first part of the Wang test, which is the conduct. And Grimsley, the intent arguably was that he was trying to have the team proceed with the game. So the heckler was interfering with their ability to better perform. I don't agree with it, but I think that the intent is there. The intent here was then to sexually harass someone that they didn't agree with. You know what I mean? It wasn't to further the game or the team. I think the intent is the underlying.
But why were they sexually harassing her?
To get her out.
To get her out, which is what the players wanted, which would then
Make them happier.
Make them happier and perform better, no?
But if the owner is saying the reporters have the right to be in there, how is that?
How is that motivated in part to serve the interests of the employer?
Correct.
Better team performance at the end of the day. That's what his argument is.
To go against the employer's directive of allowing reporters in the locker room?
Sure. Yeah, the employer's not. Your employer always right?
But again, it's not the owners, it's the NFL mandate, and the owners have to abide
The
by it.
NFL do anything about this?
I don't. I think some of them were suspended for a period of time. But so, I mean, you're all. Is it that Grimsley's just wrong then? Because that's good. Not yet.
The conduct, the first element, he was throwing the ball, and that's what he's supposed to do as a pitcher, not in that way, obviously. And then also, he was motivated. He wanted to win the game, and his concentration as the pitcher, the game is kind of in his hands. So I think it's a closer argument.
I guess you could get away with it. It could have been an accident.
But he didn't say that. He said no. You're right. His testimony is damn right. I threw at his head, and I did it because I was going to quiet him so that we could play better. That's his explanation. And the court says, okay, you satisfy the Wang test, but Timpson does not. And I think Matt's distinctions, right? I mean, he is absolutely dead on with what he was hired to do, was throw a baseball, not there. And again, as twisted as his logic is, we stop this, we might win this game. Where I think Timpson has a better argument on 1 than 3. Because I do think he can argue this is the type of conduct I'm expected to perform because you're the one that makes me have to talk to these press people. I don't want to talk to them, but I will do so as part of my job. I want to play football. So I think he's closer on 1 than he's on 3, because I think that's where Grimsley might be a little better, where he can say, well, we still wanted to win the game. We wanted to have an ability to do better. Without this heckler there, we could. And frankly, I don't think anyone else is going to heckle the rest of that game. So that at least that is maybe closer to satisfying 3 than Timpson.
Okay, he is hired and he has to do certain duties in order to talk to the reporter. However, in a respectful manner, ethically, he has an image to protect at the end of the day. I don't think they said, oh yeah, go ahead and disrespect everybody's seat just to make sure the team's okay. There's a borderline where at the end of the day.
But isn't the image of the football player, do you think that they were serving the image of the football player as some, rowdy, barbaric, group? I think psychologically they might have been thinking that's what is expected of them. They're rowdy, they're raw. The image thing is very loose.
I think he's closer on 3 than he is on 1. I mean, one is the conduct of the kind of employer that he's employed to perform. I mean, it's hard to argue that
But I have to-
sexual harassment.
No, but I have to engage with my teammates.
Right.
And I have to speak to the press.
Right, but 3, I think, where there was a manager for the Patriots there, I think that's a way better argument because the same argument that you make for 1, like, I was hired as a team. Also, my boss is right there laughing next to me. You know what I mean? So, I mean, I think 3 is, he has a really good argument. I mean, 1 would be tough to convince somebody, I think. You know what I
I don't
mean?
think management cared. They were 1-15. They had 10. I was a season ticket holder. It was me, my 10 buddies, and about 5,000.
Where were they then? Were they at Schaefer? Was it Foxborough still?
No, it was Schaefer, the old stadium.
So let me ask you then. Suppose Timpson actually sexually assaults her there. I guess it's not the Patriots' responsibility because he's not an authorized agent. Right? I mean, in order to hold the employer liable, that's why we do the Wang test, is the employer responsible for the acts of their agent, right? Is the master responsible for the acts of their agent? And unless you satisfy 1, 2, and 3, it's not a responde ad superior argument, which, by the way, means, because I bring it, so if your boss rapes you at work, you can't sue Kentucky Fried Chicken or whoever it is.
Couldn't you still sue for
Go ahead.
negligent supervision?
Well, okay, but not for responde ad superior. That's I want to make sure.
Is that the same as vicarious liability?
Yeah, but right. So we're all on the same page that that's not going to satisfy the 3-part Wang test. Negligent supervision, hostile work environment. But suppose from your negligent supervision, we had no idea before. No one else ever reported it. The person just snapped. Rape the employee. You can't satisfy the Wang test on that, can you? You've got the conduct. He is the type he was hired to perform. No one hires you to do rape or sexual harassment, right?
Well, you could argue for that he was supervising. So.
Well, so that's how you supervise, and you think that's a better argument than Timpson?
No, I'm saying in his active supervision, like his broad action was supervising his inferior.
Okay, but we're talking about the specific action in question here, which is non-consensual sexual activity with a subordinate.
Then you would say the same thing for the Patriots case because.
Well, but the Patriots case, you guys all agreed with the Patriots case. You said, yeah, he can't satisfy 1 or 3. Right? That's what you said, and that appears to be the law, right? I mean, this is a Supreme Court case. So that appears to be the law, that he's outside 1 and 3, and I agree. I'm not saying
KFC.
Huh?
So you can't sue KFC.
So, so you're comfortable with that? So, but that's the rule, isn't it? If you can't show, unless you have to have a different legal theory. That's Matt's point. Okay, hostile work environment, negligent supervision, negligent hiring, something else. But if
I think in a situation like that, you're not going to really care about civil damages. You're going to be more curious or more worried about criminal.
Oh, I'm going to be looking for civil damages.
Yeah, but I don't know. I've never been sexually assaulted or raped, but if someone raped me, I'd probably be more concerned about putting the bast behind bars than getting dollars.
That's obviously going to be your first effort, first attempt, and I don't blame you. And then we're talking potentially millions of dollars. Would that get you enough therapy and the rest that hopefully you'll be able to live with some of this? Because I would imagine. I would imagine. Listen, I think it wouldn't take much to be able to put forward a pretty good damage model that we are. Well, if you were sitting on a jury, wouldn't you award millions potentially for the psychological damage and the trauma of all of that? I mean, it doesn't take a lot to build that case. So I agree that there'll be criminal charges, and that's by the way, that's why I don't want that's why the manager serves me no purpose whatsoever, because he's not likely ever to work again, and even if he is, it's not going to be making the type of money that would satisfy this judgment. I need KFC. I need the employer. But are they outside the scope? And so if these guys were outside the scope, Patriots aren't responsible under respondeat et superior or under that argument, right? Master-servant relationship. You all good with that, or you don't like that result? You don't like that result, Marcia. But that would be what naturally follows here, right? And this is part of the problem as you start to think about, so okay, how do we extend this and to those situations at work where someone now is acting outside the scope of their employment to serve their own interests, but they're doing things at work that potentially create liability, because it's their own liability then, isn't it?
What was the what was the theory for all of the priests that molested the kids?
The negligent supervision. The fact is, the church had ample information that these activities were going on, and instead of doing anything about it, they simply reassigned the priests more often than not. So that's at some point, and then that's right. At some point, it's a different theory, but it's not necessarily respondeat et superior.
That's negligent. That's different. That's if you have evidence that they, that they're negligent.
Right, but a lot of times in these situations, someone acts in a way that we never expected. There's nothing there that would indicate it, but all of a sudden we've got a huge problem. And if you think about this three-part test, it would be very difficult for almost any of these situations then to argue that that's within the scope of employment.
But in a way, I kind of agree with that. I mean, why should KFC? Assuming they have, let's say, if there's negligence, if they hire a guy and he's got all these sexual assault things in his past, fine. But if somebody just you hire a guy and he goes nuts one day, you really shouldn't be held responsible, just because you employed him. You know what I mean?
Well, you made him a supervisor, and now he has raped someone under his supervision.
Right, which is horrible. But
They're still liable.
I don't know why you should be liable. You know what I mean?
Still probably got pretty good leverage to settle the case. That's going to be a bad press for them.
Well, but it's press. It's not necessarily law, right? And what were you guys saying over there? You should be liable.
Yeah.
But how are you going to make them liable? It's not a liability. Are you saying that somehow you're going to figure out a way that that's going to satisfy the test that Timson couldn't satisfy? Because it certainly can't be the conduct I hired you to perform. It can't possibly, right? No one hires an employee to do that type of behavior. Not, right? So you can't get past the first part of it. Again, you're probably okay on 2, assuming it happens in, where you work. And I don't see you fashioning much of an argument on 3 either. So you're out. So there's no liability. Not under respondeat et superior. You don't like that result, though. I can see your looks on your faces.
No, why should there be? I don't get I get it, but why?
Well, because you put this unstable, dangerous person in a place of supervision, and now they have
if there's evidence
damaged
of that.
an employee. Oh, by the way, they damaged an employee in the course of their employment. So the likelihood is you might have a workers' comp claim, because it really oftentimes doesn't matter how you were injured if you were injured during the course of your employment. So you have a workers' comp claim. Workers' comp claim is not going to get you money that this would get you before a civil jury at all.
What if the guy was a model employee for 5 years, had no prior criminal...
You're out. Right.
School, never been in trouble, anything. He just snapped one day and...
There's no liability, right? Because you don't have... I don't think you have a negligent entrustment. Doesn't sound like you have a hostile work environment claim. And you don't have respondeat et superior. We face these types of issues in a lot of these cases, you realize. Even just think, this case I described to you, there was a pattern of years worth of harassment by fellow employees, years, and supervisors. And the argument is, at least the argument by the company is, we're not, there's an insurance policy, so it's not going to be an issue necessarily, but we're not going to be responsible for acts that employees do inside or outside the building that are harassment. We don't pay anyone, and we don't hire anyone to harass the others. We have firm policies against it. Right? You're going to have a tough time with the Wang. You got to extend it to the negligent supervision and the hostile work environment claims. Well, there's activities going on that you allowed to go on. You've now created a dangerous workplace. But it's not a classic responde ad superior argument, unless you want to say, well, it's maybe closer to Grimsley.
Does the insurance thing muck it up at all as far as liability compared to like an employer-employee, or is it the same thing within the scope?
Listen, here's the other part of the problem. The insurance company may reject the claims as well. They may say, just like they did with Tinson, we will defend under a reservation of our rights. But if these are intentional criminal acts, you have no coverage under the policies for intentional criminal acts created by employees, period. And so the fact is that rape claim may not be covered under the policy either, because it doesn't have to be. It's the same reason. They're not, we've got this model employee who snaps. We could never have known. It's a horrible situation, but we have no liability here, even though it occurs in the workspace. Go ahead.
At one point in time, you don't hear about it anymore, but there was a wave of post office attacks, hence the term going postal.
Yep.
What happened in those types of cases? What was the...
What do you mean, by a postal worker against others? I don't know, but you're going to face the same hurdle if you start to think about it, right? Is that, well, how can I satisfy the responde ad superior argument? And the fact is that if you take Tinson and you apply the same standard you apply to Tinson, you're going to have a real tough time with 1 and 3. 2, oftentimes they happen in the workspace. Listen, there was one down here in Wakefield just a few years back, right? A fellow employee goes in, shoots up the office, kills people, right? Mako?
The gentle giant.
That's his name?
Mako, yeah.
So he shoots up the place. Well, that's not on me, even though it happens in work necessarily. And by the way, they're not going to. These are multi-million-dollar claims. Neither the insurance company or the corporation itself is going to do the right thing necessarily, because it's too much money at stake.
If you can get affidavits from coworkers who said like that manager was always weird and that sort of thing, then don't you have an issue of fact to put before a jury, and you probably have some leverage to settle the case?
But again, on one of your other arguments, negligent entrustment or hostile work environment, he used to leer at her, he used to make sexually suggestive comments, whatever it is. And that's the thing, though. It's got to be a different argument, because what it can't be is responde ad superior, because the likelihood of satisfying 1 and 3. You saw what we went through in Tinson. I think, frankly, Tinson is a lot closer than the rape at work or the other type of sexual assault claims at work, assuming, just on the basis of responde ad superior, without knowing about negligent entrustment and all the rest. Tinson's probably closer.
If you made that argument, you're almost making it on just being an authorized time and space, which then means you could essentially sue the city because you were raped anywhere.
That's why it's a 3-part test and not a 1-part test, because otherwise it's just it makes it a geography question, not necessarily are there other reasons why they should be liable. Okay? See you on Thursday.